Well, smartphones have taken over our lives faster than the law is able to keep up with. And, well, what's going on? What should you do if you get in trouble with your phone? Jim Pikl is here. He is an experienced trial and appellate lawyer. Jim, what is going on? What are the rules regarding smartphones? And if the cops want it, do I just have to give it to them?
Well, when you say give it to them, do you mean the actual physical device or the contents of the phone?
Well, I guess both. I mean, I guess they can they could take anything they want from me, but that doesn't mean I got to tell them my password or give them my fingerprint, do I?
Well, technically, the police can't just take anything they want from you. They have to have a warrant to acquire your property or believe that you're in the commission of a crime.
Well, what if you're okay? You get pulled over and they start looking at, they start asking for stuff when you get pulled over.
Well, again, there's all kinds of issues with the Terry versus Ohio stop by the police, whether stuff is visible to the police, whether they have to intrude on the space of the car. It's a complicated constitutional issue, Fourth Amendment issue on traffic stops.
Okay.
On cell phone, I think the Virginia case is what I was asked to speak about today, which is where a guy is accused of shooting upskirt videos with his cell phone, gets caught, cops get a search warrant for the cell phone, and then the question is, does the suspect have to give the police his passcode so they can open the phone to see if there are any incriminating videos on the phone?
Right, so he's saying, I'm not telling you because I've done something wrong. I don't want the popo to find out. So he says, I'm not telling you.
Right.
So what is
That's what he did. He said, I'm not going to tell. Well, actually, when he was first caught, he said, oh, yeah, here's my phone. Go ahead and look at it. And then they said, well, we need your passcode. And he said, nope, I changed my mind. You're not going to get to look at it. So they went and got a warrant, and the search warrant they got did not give the police the right to get the phone. It gave the police the right to get the contents of the phone, which are different. That's why I started out saying there's a difference between the physical object and the information in the object. So police got a warrant. He still refused to give the police his passcode. The trial court said, nope, Fifth Amendment, you don't have to give it to him. Court of Appeals in Florida said, Court of Appeals in Florida, it's a Florida case. Court of Appeals said, yes, you do. You do have to give it to them because giving them your passcode is not testimonial evidence. It's merely the same thing basically as providing a fingerprint. And there were other cases out there, particularly from Florida, where the courts have said if they get your cell phone, you have one of those unlockers on your phone like I do where you can just put your thumb on the on-off button. They can force you to put your thumb on the on-off button, which unlocks the phone too.
Man.
And the Court of Appeals in Florida said that's no different from requiring the suspect to give the passcode.
Okay, let's say I say, I'm not doing it. Not doing it. Well, you have to get a passcode. I'm not doing it. What can they do to me?
Well, if the court orders you to give them the passcode and your Fifth Amendment right has been up and down the appellate chain and been decided you don't have a Fifth Amendment right to refuse to provide the evidence, they can jail you for contempt. And they can jail you indefinitely for contempt because you have the keys to the jailhouse door, so to speak. All you have to do is just agree to do what the court's ordered you to do, and you get out. So you can spend the rest of your life in jail, essentially.
I might do that under principle, even though I don't have anything on my phone I don't worry about. I'm just saying I don't think that's right. How about you?
Well, this is the first impression case out of Florida. The only other ones before have been fingerprint cases, the fingerprint case out of Florida, where they say fingerprints are not testimony. In other words, a fingerprint is like a key. It's something that you possess. It's not something that's in your mind. And the courts are starting to draw, except for this case that we're talking about today out of Florida, the courts are starting to draw a distinction, I think, between things that are in your mind that aren't physical objects, like your fingerprint, and physical objects, which the law is pretty clear on that for a long time back, that the court can compel you to give physical objects, like a key to a safe. If they search your house and they come into your house and there's a safe,
right,
and you say, I'm not going to give you the key, the courts can order you to give them a key because giving them the key is not incriminating in any way. Now, what's inside the safe might be incriminating, but just by giving them the key, that's not a crime. So you're not incriminating yourself by turning over a key.
Right.
You're not incriminating yourself by turning over a fingerprint. You're not incriminating yourself by turning over a blood sample. but something that's in your brain, something that is not tangible. I think the courts are kind of starting to come down on one side or the other of that issue. But for the Florida case, the Stahl case that just came out last week, they've been pretty clear about that and pretty consistent. And now the Stahl case has sort of kicked the anthill on that a little bit.
All right. Hey, Jim Pikl, I appreciate it. You have a website you'd like people to go to?
My website, my firm's website is www.solidcounsel.com.
Okay.
In Dallas.
All right. Thank you so much for being here in Training Today USA. I appreciate it.